There is definitely a world where this gets appealed and thrown out and he remains free, which he is now. It's not just a right in some abstract sense. It is legal for U.S. citizens to use Tornado Cash. The ability to have digital privacy in a true sense is like important for the future of human development, really. They're trying to shoehorn these people who are not in that intermediary role into the legal responsibility of having the intermediary role, because they want to put it on somebody. If you know a little bit of history and context and politics, you can tell that there's very clearly an agenda being advanced.
This episode of Supply Shock is brought to you by Ledn, a proud Bitcoin-only company and the global leader in Bitcoin-backed lending. Need cash but don't want to sell down your Bitcoin stack? Ledn has a trusted track record in providing liquidity. That's Ledn. You'll hear more about them later in this episode. As always, investments in blockchain technology involve risk. Terms and conditions may apply. Do your own research. The Blockworks Digital Asset Summit, crypto's premier institutional event, is coming back to London this October, the 13th to the 15th. You'll hear from top names across global finance, DeFi, and policy. Think BlackRock, Circle, Coinbase, and the UK Parliament. Notable speakers already locked in include Danny Masters from CoinShares, Jeff Park from Bitwise, and plenty more to come. There's also a VIP dinner on October the 13th. That's for speakers and VIP ticket holders only. It will sell out. It's all happening at the Old Billingsgate in London. Use code SUPPLY100 at checkout for £100 off. Quick reminder, nothing said on Supply Shock is a recommendation to buy or sell any investment or product. This podcast is for informational purposes only, and the views expressed by anyone on the show are solely their opinions, not financial advice or necessarily the views of Blockworks. Our hosts, guests, and the Blockworks team may hold positions the company, sponsor, or projects discussed. Hey everybody, Pete Rizzo, the Bitcoin historian on X, here bringing you a very important story today, one that hits near and dear to the heart of why Bitcoin and cryptocurrencies were started all those years ago by Satoshi Nakamoto, and even before that, the cypherpunk movement, which sought to advance a certain view and values to the world through technology. Of course, I'm talking about the Roman Storm trial. This is the co-founder and developer of Tornado Cash, who was found guilty by a Manhattan jury of a conspiracy to operate an unlicensed money transmitting business, all for a piece of software that he wrote. The verdict was delivered earlier this month after a 3-week trial. He now faces a maximum sentence of 5 years in federal prison. Here to break down the case and tell you why this is so important, we've got David Z. Morris, author of the forthcoming book, Stealing the Future, a look into the Sam Bankman-Fried saga. He was, of course, a contributor to The Rage during the trial, where his online videos went viral as coverage was breaking out in New York and into the world. David, welcome to the podcast.
Thanks, Pete. Good to be here.
Well, excited to dive into this. Well, maybe not excited in the right word, but excited to catch up. Obviously, the subject matter, one that a lot of people really deeply care about, and the case troubling to many given the implications. Maybe you can start with the verdict and what Roman is facing, and all that hangs in the balance as a result of this trial.
You know, there is a lot of good news here, I think, for people who I think are on this side of the aisle, so to speak, because there was a verdict, but also there were, in a couple of important cases, no verdicts, and that is on the charges of conspiracy to commit money laundering and conspiracy to commit sanctions violations. He was found not guilty by the jury, or not. I screwed it up already because it's so complicated. The jury was not able to reach a decision on those charges. So you had a hung jury and a mistrial, effectively. That means that the federal government can retry those charges if it wants to. That's an open question that we can talk about, but there's no guilty verdict. So he did escape what could have been the very worst impacts of this, because each of those charges carried a potential sentence of 20 years. The third charge, the charge that he was convicted on, which we can go into depth about kind of the weirdness of it. And frankly, the reason that he was convicted was, at least according to some analysts, really more of a technical matter than the jury thinking that he actually committed a substantive crime. But he did get a guilty charge on that. Even in court, because of some of these complexities that we'll get into, the judge Catherine Fila, who was the sitting judge here, acknowledged that there's an easy path to appeal on this charge where he was. I shouldn't say easy. There's a clear path to appeal. Obviously, whether it's successful or not depends on a lot. But there's clear reasons to appeal this judgment on the money transmitting charge, and even Judge Filey acknowledged that from the bench. So there is a world where he serves 5 years. There's a world much more likely than that where he serves a couple of years, and there is definitely a world where this gets appealed and thrown out, and he remains free, which he is now.
Well, let's do a little recap. Obviously, people are familiar with Tornado Cash, maybe in the broad strokes. They know that it's become sort of a message and sort of a meme for a movement of people who care about financial privacy. Can you take us back to the arrest of Roman Storm and sort of the really early beginnings of this case? Obviously, he deployed a piece of code online that he authored that ran afoul of the government, and that sort of set in motion all that you just discussed.
Yeah, and I think it's important to actually even go back before the arrest and the charges, because the story really, at least the story that we got at trial, really begins in around 2019 when Roman Storm, Roman Semenov, and Alexei Pertsev, the latter of two, we can discuss their situations. They were all three, I believe, at East Boston. So they were in Boston. I think this was on the Harvard campus at a hackathon. They had already received advice from people, including Vitalik Buterin, co-founder of Ethereum, that if they wanted to build something very useful on Ethereum, privacy was what was needed the most. And there was a lot of evidence presented at trial to the effect that there is this community on Ethereum who, are fundamentally good actors, honest people, not North Korean hackers, who wanted this privacy technology to exist, who in these very mainstream public venues discussed the creation of this. And I think that that's somewhat reflected in the hung jury, the fact that, there were all these legitimate users and legitimate fans. A lot of the people who were witnesses for both the prosecution and the defense said that they admired, in some sense or another, what the Tornado Cash people had built as both technology and as a privacy service. So the foundations of this, it's really, if you're coming at it from somebody like us who's been involved in crypto for a long time, and specifically I've been very aware of what's going on in Ethereum for a long time, from that inside view, you can see how building something like this would just feel like a very professional, public, open, normal thing to do. And so they did, going into 2020, 2021, they developed this code. They deployed it. And by 2020, they had actually, and this is kind of key to the timeline here, by 2020, they had locked the contracts and the pools that make up Tornado Cash, which we can get into the technicalities there. But, just the same way that, I can't think of a parallel on Bitcoin, but that's probably just sheer ignorance. There, you can just deploy these, devices that exist without any active intervention from the people who actually created them. And that's key, because after that 2020 date, nobody could change the back end operation of Tornado Cash. Now, one of the important aspects of the trial is that Pertsev, Storm, and Semenov founded a company called PepperSec, and PepperSec did maintain certain ancillary services to Tornado Cash. So the web interface, where it was very easy to use, and also sort of back end mechanisms called routers and relayers that had various functions. And, they had varying degrees of control over those systems and operations. But, the crime that is charged, at least in the initial, indictment, there was a lot of focus on the Ronin hack, which I'm going to perhaps get this wrong, but I believe took place in 2022. So 2 years after the code for Tornado Cash was locked. And there was a total of about $600 million stolen by, we now know, DPRK hackers, going by the notorious Lazarus Group. So they stole a bunch of money, and then it started going through Tornado Cash. At this point, the principals all panicked. This was the largest tranche. There had been sort of other incidents where major hacks had been, some of them gone through Tornado Cash, and people had seen that, because once you can observe on chain, things go right up to the edge of the Tornado Cash pools. So you kind of know what's going in. And the creators of Tornado Cash some of the evidence at trial that was, I think, the most interesting and the most open to interpretation was, at this point, they sort of panicked. We have records of text messages thanks to Alexei Pertsev's phone getting seized in the Netherlands. And so we see them sort of panicking, essentially, as all these hacked funds start going through Tornado Cash, saying things like, we're fucked. These idiots are destroying our statistics. These are basically quotes from the chats. But the government at trial really tried to depict this as awareness of crimes being committed using things that they controlled. And these are the sort of debates that I think the jury had to weigh in on their take on. And I think, again, the hung jury on these charges makes clear that these, they did not entirely buy the idea either that Tornado Cash was built for criminal purposes or that the co-founders were just sort of like perfectly happy to have criminals use them.
Well, it's a complicated subject with a long history in the space. I was going to say, just to maybe contextualize people, right? There's this idea that, when I have or I purchase a Bitcoin, I receive, or, cryptocurrency, I receive a pair of private keys. I also have some sort of, imprint on the blockchain. And then, what right do I have to take steps, to control how that imprint is perceived, right? So in the Bitcoin context, the Samurai Wallet developers, having put in place, a mechanism by which people could swap, these UTXOs and Bitcoin, but essentially on-chain proof that they own the funds with other users in order to control their anonymity set. And sort of that being kind of viewed as a right? Like there's an effort within this community to kind of position this user choice, right? My ability to control how I am perceived within the blockchain public network as sort of a right. So I was wondering if you could speak to that. I mean, obviously, I know that was a huge component of the defense.
It's not just a right in some abstract sense. It is legal for U.S. citizens to use Tornado Cash. I'm unfamiliar with the technicalities of Samurai Wallet, so unfortunately, I'm not sure where the differences there lie. I'm going to, be learning more about that going forward, but it is legal right now. And of course, because Tornado Cash is immutable code, it exists on chain on Ethereum right now. You have to be very careful, by the way, as a public service announcement, because a lot of the front ends have been hijacked by governance attacks with the founders in jail. So a lot of the stuff you might find on the web is not going to be is going to get you your money stolen. So be careful about that. But it's legal for you to anonymize your own funds on chain. That is quite clear. And, as long as it's not towards a criminal purpose and as long as they're not the proceeds of criminal activity, that is literally your right, at least in the U.S. where Tornado Cash is no longer on the sanctions list. But, yes, the bigger sort of ideological fight over, this should be legal in a very substantive sense. That's, I think, really the key question is not just, is this legal in theory, but is it really substantively legal? Because one of the major, one of the key witnesses for the prosecution, which, obviously based on the verdict, maybe not that effective, was a guy who came in and proposed an alternate model for Tornado Cash that the government was saying, like, you could have built it in this way that didn't enable criminal money launderers to use it. But this alternative model was, give us your name and all of your banking information. We'll keep it in a private record, and we'll also manage all of the mixing so that we actually have total records of who has done everything on the system, which obviously that is actually not real privacy, even for a completely non-criminal, average user who, as one of the defense witnesses testified, just wants to kind of like keep some control over who can tell what they're invested in personally, for example. I think that's quite reasonable. And I think, again, the jury understood that to some extent. And I think that that is reflected in the hung jury verdict.
They call it the hodler's dilemma. Ever wish you could get access to cash without selling down your stack? Well, Ledn makes that possible. Since 2018, Ledn has issued over $9 billion worth of Bitcoin-backed loans, and they haven't lost a single satoshi of client funds in the process. There are no credit checks. You can get funds in under 12 hours and repay whenever you want with zero penalties. Unlike others, Ledn doesn't lend out your collateral. They even publish biannual proof of reserves verified by top auditors in the blockchain. You can learn more at ledn.io. That's ledn.io. As always, investments in blockchain technology involve risk. Terms and conditions may apply. Do your own research. Well, yeah, then a bit of a clarification. I was looking up there just to make sure we get the facts right, but a lot of similarities between the Samurai and Ethereum case in terms of allowing users to essentially kind of conduct this mixing. In the case of Samurai, you're due to some limitations in Bitcoin using, something that's operated by, essentially a server, but the funds are controlled by the user. That's the argument from the Samurai folks. And Ethereum, that apparatus is the smart contract, which you said, or eloquently said is frozen, but essentially the same idea, right? Users want to control how their funds are viewed on chain and this financial privacy context. And so I guess my question, we talked about how the jury maybe reacted to this. I want to talk maybe about how the defense was mounted and what insight that you can give there. I know there was, a lot of people following very, very closely. Do you feel like there was a set of key moments here that played out, whereas you were watching? I know, we'll probably cut to some of your live courthouse videos, but do you have a sense that there were sort of key moments in the development and the actual courthouse trial here?
I'm not by any means a veteran courthouse reporter, but I've done a couple criminal trials at this point. And this is definitely, of what I've seen, the most procedurally intense trial. That is, a lot of the stuff that was very important happened when the jury was not present. It was not about evidence. It was about negotiating very fine sort of points of law before the jury even entered the picture. And I think, I'm cribbing, and I will a couple more times. I'm cribbing from Peter Van Valkenburg on this, but I think the really key element or the key moment of the trial actually happened before the trial even began, especially given the outcome, because that was really when, in response to the defense filed a motion to dismiss on the basis, in part, that the money transmission charge actually contradicted FinCEN guidance. In 2019, FinCEN issued guidance saying that if you don't actually have custody over a customer's money, you are not a money transmitting business. So this charge that was filed in 2022 or 23 contradicted this previous regulatory guidance. That was part of the defense's motion to dismiss before the trial even really started.
I think that might even go back further than that, because that's been a long-standing FinCEN position since 2013. That essentially, and they were one of the really early regulators to sort of define like
that sounds right,
even as like a non-custodial wallet. Because even as far back as 2013, 14, there was initial kind of rush of companies, maybe as far back as then, maybe people don't know this, but Coinbase then wasn't an exchange, it was a wallet. Blockchain.info, or blockchain as it's known today, was as well. And there was a real early kind of effort to distinguish non-custodial wallets, but as this case shows, it still is a fight today, because it's a concept that really just doesn't exist in legacy finance, where generally, unless you're holding cash in your wallet, there's some other custodian or responsible entity.
Yeah, and that's really what this case is fundamentally about. So really good point, which is they are essentially trying to position the Romans and Alexei as intermediaries, as people who had the ability and responsibility to act as this proxy agent that essentially, Niraj has the famous tweet, right? Like, I'm sorry, your surveillance regime assumed the continued existence of surveillance intermediaries, or something like that. I'm fucking it up. He's more eloquent than me, but that's exactly what's happening right here, which is they're trying to shoehorn these people who are not in that intermediary role into the legal responsibility of having the intermediary role, because they want to put it on somebody. Essentially is what it boils down to. And they had this theory of the case that they didn't succeed in proving this time, and we'll see if they take a shot again.
Well, I'm curious to ask how you sort of got attracted to this as a journalist and storyteller, and to what extent, you went into the courtroom with sort of a feeling or sentiment about the case. I know that there's always a classic fissure in the journalism world about objectivity versus truth telling and things like that. So I'm curious to get you as you were behind the lens, and just maybe how did this assignment come your way?
That's definitely very relevant, because it's something that we're thinking about a lot at The Rage, where I was very happy to have their support in doing this work, and it's very much like an ideas and even ideology driven publication that Lola Leitz has founded there, and I think, personally, coming at it from just a journalism perspective, I would make 2 points. One is that on just the reporting process. This is something that I'm just like very excited to have discovered thanks to going to watch Sam Bankman-Fried's criminal trial. But, I live in Brooklyn. I live just a few minutes from the SDNY courthouse. And so I go down there, and I can see stuff happening firsthand. And there is just immense value to that, especially when you have a case like this, both that's really important in its implications and extremely granular in every step along the way. There is some decision being made that theoretically, like 5 days later, has an impact in the outcome of the trial. And then that trial becomes precedent basically for, much bigger issues. So it's kind of a butterfly effect that you have to be paying attention to every moment to really understand. Because these rulings about, in addition to the motion to dismiss, the defense, for example, wanted to talk specifically about the risk of physical harm, kidnapping, and blackmail that major crypto holders face because of the fact that wallets are transparent and in theory you can be traced and people can figure out how much money you have.
I mean, that's a big narrative these days. Yeah, I think there was a recent study where it's like one a week.
Yeah. Oh, really? Wow. I haven't seen that, but I'm not surprised. And I think that I also want to, like, just as a short aside, I think this is one thing where I would urge people who have a dog in this fight talking about this issue of neutrality and objectivity. I think a lot of people who are very ideologically committed here have a tendency to assume that the process itself is unfair, or that like the state has its fingers in everything and is like nudging the judge to do this, that, and the third. And I think that, I'm not going to say that's completely insane, but just based on what I was able to see in the courtroom in terms of moment to moment, I mean, the judge was making judgments that I think were based in the nature of the facts. So, for example, in this kidnapping discussion, the prosecution understandably didn't want any discussion of kidnapping, physical threats. They wanted to minimize what the jury heard about the importance of privacy, right? And so Fila's judgment on this one was actually basically to the favor of the defense, which was she allowed them to discuss any awareness of kidnappings or threats to physical privacy or physical security that Roman would have been aware of when he was building Tornado Cash. Because the state of mind is kind of a key question for this trial overall. Like, was the intent criminal? If so, he's guilty. But if the intent was to protect people and to create something that's a useful privacy tool, then he's not guilty, which clearly some members of the jury thought that was the correct.
Right, that was what there was emphasis on, his fundraising efforts and the commercialization component of it, correct?
Yes, and that's sort of another aspect of it, which is the prosecution also wanted to show that there was a profit motive, because that's sort of one of the components of a money laundering charge, and more generally kind of can be tied into criminal intent if your intent is to make money. And even when I was reporting for CoinDesk back circa 2021 2022 when Tornado Cash was coming out, and I have to say that even then I was very skeptical of any tool of that nature that had a revenue model that could be tied back to the founders. And in this case, it was definitely a little bit abstracted. There was a token, the Torn token. There were no fees being charged by the protocol, but the Torn token through the relayer mechanism, which again we can get into if we want to, but it's probably too boring. But they made money through the Torn token. That became a significant portion of the prosecution's argument that they loved seeing these big criminal inflows because it meant they made more money from their token holdings. So yeah, that like the revenue model, and this is also sort of relevant for people building decentralized protocols, that like they will get you on the revenue side if they want, or they will at least try to. That sort of undermines some claims to decentralization, I think it's fair to say.
Well, I think maybe the root question I was trying to ask is, your view as a journalist towards financial privacy. Is that something you have like a real tug on your heartstrings for? Do you have sort of an idea that this is sort of a true thing that's kind of worth fighting for through journalism, or are you
absolutely. And I'm sorry I got off topic, but I think The Rage is a sort of purpose-driven organization, and I think that personally, what the way I think of it is that objectivity is not the same thing as neutrality. And so when I'm talking about people who are kind of like preemptively upset that the judge is biased or something like that, I think that that's where, you have to actually, like, even if you are not objective, even if you have a certain viewpoint, you have to look at the facts, neutrally, right? Like you have to, or maybe I'm backwards, but anyway, you can have your opinion, but you still have to pay attention to the facts, and you can't sort of put your presumptions ahead of the facts. And I actually think that those things are not just things you can balance, but things that actually like improve journalism. And frankly, I think part of the problem with, this is not an original observation, but I think some of the problem with people's distrust in journalism has to do with this sort of overarching claim to being neutral, or like not having a perspective at all, when in fact, like, you read the stuff, and especially if you know a little bit of history and context and politics, you can tell that there's very clearly an agenda being advanced. I think that readers, I would anticipate readers respond better when you are clear about your purpose and your perspective, but then also give them the facts about what's going on, which is what we try to do here, with just being very attentive to the legal details of the actual process. And in the course of the reporting, I think I tried to stay away from the really big picture, and drawing too many conclusions maybe would be one way to try and balance those two things. But certainly personally, I think that, for a lot of reasons, I think that the ability to have digital privacy in a true sense is like important for the future of human development, really. And we are also living in a moment where, for various reasons, I would have hoped it would be more obvious to more people that that level of privacy is, sort of essential for individuals more and more, unfortunately.
Was there a moment where you felt then, since it sounds like you're very values aligned here with, the defense, that you almost felt like, sort of, I guess maybe I use the word outraged, but I guess, a strong pull of emotion, towards what they had to endure?
I would reserve the word outraged because I feel like that's personal. And one of the things that I also try and do when I'm balancing these, like, I have a perspective, but I want to be fair to everybody involved, is, prosecutors, and a lot of people, perhaps some of your listeners will disagree with me on this, but like, prosecutors are doing their jobs, and their job is to be as tactically effective as possible. And so I wouldn't say outraged, but I will say that the prosecution in this case made some mistakes and then tried to essentially cover up for them in ways that I can understand their motivations, and they're trying to play the game as hard as they can. But it wound up really being bad. And I think I'll get into a case in an example, but I think that if Roman had been found guilty, it would have been, these are grounds for a real mistrial. And then maybe I would have gotten more worked up about them, but it ultimately didn't wind up at least getting him this time. And the specific instance that I'm talking about is the prosecution's very first witness was a woman who may not have had anything to do with Tornado Cash whatsoever. I'll try and tell this story very briefly, but the first witness they put on the stand was a woman named Hongfeng Lin, who was unfortunately the victim of a catfishing and pig butchering scam, basically like a romance Bitcoin swindle. She sent like $250,000 to some stranger on the internet. And then, and she was told by a reporting organization, a recovery organization, that her money had gone to Tornado Cash. And it appears that the prosecution put her on the stand simply on the basis of this report from a third-party organization called payback.com, because they didn't have any of their actual witnesses initially assigned to do the tracing to prove that her money wound up there. And it turns out that payback.com is a scam that is itself under investigation by the FBI. So this was the basis for their first witness to come in. And it actually, Paul Graywall, the chief legal officer of Coinbase, after some of this stuff came out, Coinbase was also listed on this initial report from payback.com, along with FTX and maybe Huobi, as having received some of her funds. Paul Graywall, the day after this breaks, comes out and says, no, we have no evidence whatsoever, because we know this woman's addresses. There's no evidence that any of this money ever went through Coinbase. So we now have Coinbase's chief legal officer saying, no, this report that the government seems to have been relying on for her testimony is clearly wrong. And so what then happened, the prosecution had a witness still waiting who had done forensic accounting having to do with Tornado Cash's fundraising. And they effectively at the last minute assigned him to also trace Katie Lynn's funds to Tornado Cash. He uses an unconventional and some would say false method called last in, first out accounting to trace these funds. But it's not an actual custody tracing. He doesn't have any idea who the owners of all the intermediary wallets are. And on cross-examination, he actually admits that this does not prove at all that Hanfeng Lin's funds were specifically moved by hackers into or scammers into Tornado Cash. So essentially the first witness, which was her testimony was allowed to stand after all of this, but essentially there is no evidence that her money was actually put through Tornado Cash, which is staggering. And so that's probably the closest I came to outrage as to kind of the procedural elements of the trial. But again, that was kind of left up to the jury to make that determination of like how much weight do we put on this person's testimony, given that the tracing expert did in fact admit under oath that his trace didn't prove anything. And again, it seems like in that hung jury, you can perhaps see their judgment that was not convincing to them. So maybe it all came out in the end in the wash.
Yeah, I mean, I'm curious, maybe a couple things, but I would say, to your observation of the jury, it's, this is such a complex thing, right? We're watching Congress now, we're on our third or fourth SEC hearings, even define some of the basic concepts around crypto and blockchains. Did you feel like they were just kind of at a disadvantage? I don't know to the extent that you talked to them personally or reported on how they reacted to things. Obviously it must be a strange assignment to get, if you're, selected for a jury trial and you're on this case. I'm sure none of them really had a deep expertise in this area. Maybe can you tell us a little bit about their experience? Let's take a quick break to talk about today's sponsor, Ledn, the most trusted name in Bitcoin-backed lending. Look, if you're like me, you never really want to think about selling your Bitcoin. Ledn has a solution. You can borrow against your Bitcoin. No credit checks, no monthly payments, no hidden fees. You can get your cash in under 12 hours and pay back when you want with zero penalties. Unlike other platforms, Ledn has a history of transparency. They prove it with independent proof of reserves audits every 6 months on the blockchain. In total, they've issued more than $9 billion in loans without losing a single satoshi of client funds. That's the kind of track record you want when it comes to securing your Bitcoin. You can learn more. Visit ledn.io. That's ledn.io. As always, investments in blockchain technology involve risk. Terms and conditions may apply. Do your own research.
Yeah, unfortunately, I did after the jury is released, after there's a verdict, they are allowed to talk to to journalists, and I hung out outside the courthouse, kind of like looking around for a while, hoping I could catch somebody, but I wasn't lucky enough to get to speak to anybody directly after. But based on what I saw, I think the jury was very rigorous and really as much as there is important technical stuff for them to understand, I think what was very clear, based on essentially the process of their deliberation, was that they were really attentive to the legal nuances. They, just to give some context here, again, I've covered a couple of other crypto criminal trials. In the others, the technical aspects were frankly not that important. Like in FTX, the technical aspects of anything going on were kind of secondary. And, the jury returned a verdict in roughly 3 hours. The other story case that I covered in person was the Safe Moon trial. If anybody remembers Safe Moon.
Oh, wow, you're at that. Yeah, that's a fun one.
Definitely not a fraud when you call it Safe Moon. But that was also open and shut case. The technical aspects were pretty straightforward. They returned a verdict in 4 hours. In this case, the jury deliberated for at least a portion of 4 days. So they deliberated for a full Thursday, a full Monday, half of that Tuesday, and then into Wednesday morning. So they were thinking very hard. And during that time, the jury is able to send requests to the judge for whether it's clarifications or more materials, evidence, things like that. They sent a bunch of requests for testimony from specific people, having to do, for example, with the standing to prosecute Roman in New York, which is a whole other question. So I think that, it's also important to remember that This is the SDNY, and we can get mad at them for, they want to claim anything that has to do with finance as their jurisdiction, because for decades and centuries even, New York really was the physical location of the finance industry. And so they do have a lot of expertise as trial lawyers, and you can understand them wanting to prosecute those. But it is also true, I think, and it's worth keeping in mind, that New York, at a population level, the jury pool that's getting pooled from, I'm going to be a bit of a chauvinist, but I think that these are people who, on average, understand finance a little bit better than any other random given American, because the industry is here. And so I think that they really did bring, and I think there were even, there were like hedge fund traders in the jury pool. I don't think any of them got selected, but those things are very common in SDNY trials. So I think that they, whether or not they understood the technical nuances, I think they understood the legal implications and were really bearing down on that. And that ultimately wound up being, I think, why they had a split decision effectively.
Well, I imagine something else hanging over this trial for your readers, and I'm curious to how you thought through this, but there's been a lot of questions about the administration has been so openly pro-crypto, pro-Bitcoin, telegraphing support, yet there really hasn't been much in the way said about, what's happening in the Samurai case, what's happening in the Tornado Cash case. Obviously, I think there's been some attempts by Frank Corva from Bitcoin Magazine to kind of, ask questions about financial privacy to some of these administration officials, and, at least some positivity in these statements, sent generally to this idea. But I have to imagine that there was discussion at the case or around the case about the administration's just view on the case, and just even allowing it to continue to the extent that it has.
Yeah, and I'll say this is where I'm not an expert, and this is the second time I'll kind of defer to Peter Van Valkenburg on the issue, which is, first of all, I will say I do think that, like, just from a DOJ perspective, like, these prosecutions were already underway. And while it's definitely theoretically possible that somebody from the administration would have come in and sort of specifically said, like, let this go, I think it is just generally, like, more politically and otherwise complicated to halt or redirect a prosecution that's already underway than, obviously we had the Blanche memo saying that they're going to halt prosecutions for non-registration if there's no other crime. And for example, because of that memo, I believe, they had to shift their focus in charging the money transmission charge, which was the one that ultimately we did get a guilty verdict on. So, there was that definitely specific impact. But frankly, if we get into the MTB charge, the impact was mostly to make things more complicated and confusing. But I think that at a high level, the administration, there has been no comment that I'm aware of coming actually from the administration. And, this is where I think that on substance, I'll defer to Peter, but I think that on kind of a vibes basis, I have to say I take a somewhat jaundiced view of the Trump administration's pro-crypto stance, because of exactly the lack of attention to really more fundamental things like this, which are the reason why some of us who have been in the space for a long time are actually here. I would have loved to hear a statement from the Trump administration on this, but I just don't, to my knowledge, I don't think we've gotten much substantive, and we certainly haven't gotten any direct intervention at the DOJ level of let's drop this case, because they did have the opportunity to just do that maybe a few months ago.
Yeah, well, I like to say there's a reason that the Genius Act was first, right? It said a lot about the administration.
Yeah, fair enough. I mean, I'm not gonna that one. I'm actually like, yeah, let's start with something simple. But from a to share your cynical viewpoint, like, they're definitely starting where the money is and not where the values are.
Well, I'm curious. We could switch now. Obviously, winding down a bit here. Talked a lot about the trial. We've talked about the verdict, your impressions. I want to talk about the precedent. You mentioned the essentially, 3 rulings on 3 separate charges, in a couple cases inconclusive. In one case, the definitive guilty verdict, the 5-year prison sentence hanging over. So how does this fight continue? Obviously, I've seen fundraising efforts. There are people who are looking to push this case forward and push it through to an appeal. What does that process look like, and what's an optimistic scenario there?
The defense has definitely signaled their intent very clearly to appeal. The timeline for that is relatively long. Roman, in theory, this was one of the strange things, is they did not even publicly schedule a sentencing hearing, which usually there's a sentencing hearing scheduled immediately after a verdict. So I'm not exactly sure why that wasn't announced. But hopefully we'll get some information about that. But more likely there will actually be an appeal before any sentence is handed down at all. Yes, they are, hoping to. I think Roman does still need some support in funding that effort. But to sort of deal with the negative case first, the important and unfortunately not entirely positive implication of these mistrials on the money laundering and sanctions violations charges is simply that there is no precedent there. And they could either, if the government decides to come back around and try and charge Roman himself on those charges again, they can absolutely do that. I mentioned Roman Semenov, who has actually, he's not a U.S. citizen. He's a Russian citizen, and he has returned to Russia, even though he's facing the same charges as Roman Storm. So, maybe they find Roman Semenov somehow and try him on the charges and get a second shot. But in both of those cases, there is still the open possibility that they can in the future establish a precedent that would, again, be the worst possible outcome, that deploying decentralized software can make you liable as a money transmitter and as a money launderer and as a sanctions violator, which, the jury was not able to determine that. But the MTB charge is, I think, again, eminently appealable for reasons having to do with the Blanche memo. So after the Blanche memo, the prosecution, and there are some nuances here that frankly I have not been able to nail down, but effectively the prosecution shifted its theory of the crime on the money transmitting charge to go from failure to register as a money transmitter or conspiracy to operate an unlicensed money transmitter to a subclause of this statute 1600 of the Unified Criminal Code, having to do with money transmission. That statute is a subsidiary of, you have to register to be a money transmitter. And it says, if you're a money transmitter and you knowingly transmit criminally derived funds or something to that effect, that's a crime. Now, and I'm cribbing from Peter Van Valkenburg, and people who want a deeper read on this directly from him, we recorded an episode of Bankless recently that I recommend you go back to. But essentially, to paraphrase Peter, what they've done is they've eliminated the charge that you have to register as a money transmitter to be a money transmitter. But this subsidiary charge establishes a weaker standard of criminal liability because it presumes that it's only talking about registered money transmitters. And again, because of FinCEN, we know that a money transmitter is something where somebody has control, where a third party has control of your funds. Because a third party as a money transmitter has control of your funds, they have this higher standard for money laundering, which is knowledge of rather than intent to. A conventional money laundering charge, you have to have criminal intent to hide the proceeds of a crime. And obviously the jury hung on that because that's intent. And a big part of the trial was showing that, there was ambiguities about Roman's criminal intent. The MTB charge is if you even know, and again, in Tornado Cash, they knew that this stuff was happening. They didn't have any ability to stop it, or they had very minimal ability to stop it. But despite that, because of the structure of the charge, if they knew the criminal funds were going through, and the charge presumes, and this was laid out by Judge Feiler this would have been laid out by Judge Feiler in her instructions to the jury, that this is a money transmitter. Within this courtroom, we're going to call Tornado Cash a money transmitter, even though in other contexts it would not be. That was one of her pretrial judgments that became so crucial. So this is when I said that the jury was just boxed into finding this guilty charge. It's kind of because of this. And again, that MTB designation is one of the avenues for an appeal. And I think given, that a lot of this stuff has been clarified, I think it's a pretty likely one that, this was a legal mistake, that this pre-classification of Tornado Cash as a money transmitter was a legal mistake. And that's where you can go for an appeal.
Well, obviously, a lot more to come there. It sounds like, in terms of the just overall landscape for financial privacy. Then, are there other cases that you're going to be focused on now, or how do you continue to follow this story as you're, chasing it for the Rage and other publications?
I'll hit a couple quickly. One is obviously we mentioned Samurai Wallet, and I think there was a lot of disappointment by, again, people sort of on our side of the aisle being pro-privacy when we saw that the Samurai developers pled guilty to a lesser charge the Thursday before the week that we got a Samurai or a Tornado Cash verdict. So the Thursday that the jury went into deliberation, or maybe it was the Wednesday before, I'm actually forgetting, but the Samurai devs pled guilty to a lesser charge. They're going to potentially, I think they're also in like the 5-year range of the potential sentences. But one of the things, so like people were worried about that because they thought it sort of indicated that the Samurai devs had, capitulated or given up. But really, I think the truth, and this is from, sort of the grapevine of people who are familiar with the government's thinking on this, I think that the reality was that the government was trying to get something done before something exactly like the verdict that actually happened in Tornado Cash, which was ambiguous. Like, we don't know. So the government, I think, was motivated to offer the Samurai guys a deal that, might wind up better than them going to trial, because they were worried about getting an ambiguous or negative result in Tornado Cash, which is why it happened the day before, like a couple of days before. So I think that there is kind of a silver lining to be read in that guilty plea that I think a lot of people have missed. And that was, the major other story that we were following. There are others that are implicated here. We actually just over the past couple of days, and again, this is more of editor Lola Leet's great work. She found this, like, Google had been
Right.
barring. I don't know whether they were in practice barring non-custodial wallets or if that was just sort of a problem with their
As
policy.
I understood the language that I saw, is the policy inferred that non-custodial wallet developers would have to present some sort of proof of some sort of license, and this was very quickly walked back by the official Google parties.
Yeah. So that, I think, and I don't want to pin everything on one turn of events, but I do think there is a world where if last week we had gotten guilty on all 3 counts for Roman Storm, maybe Google would have had a different response to the discovery of that policy. I think that maybe they would have been much more gun shy about, maybe they would have decided, we don't want non-custodial wallets because of exactly this precedent. So the two are obviously related. And I think that, maybe again, I'll talk a little bit about one final negative case or class of cases, which is everything. Because one of the pieces of testimony that was, I thought, really striking in the course of the trial, and I forget the context, but it was the defense asking a witness, does an Ethereum node contribute to the operation of Tornado Cash? And the answer still is yes, it does. Every Ethereum node, to some extent, is involved in operating Tornado Cash, just in the same way that every Bitcoin dev is involved at every level of what happens on Bitcoin, just by having built the system. And maybe you could even say like miners are involved with stuff that happens on Bitcoin because they're running the system. And these are all just like avenues of exposure that exist if the government really persists in the broadest definition of all of these things. And, you can understand where they're coming from a, compliance, public safety standpoint. You don't want this stuff out there in a way that makes it just simple and easy for money launderers to get away with giant crimes. But I think that it hopefully pushes them towards different solutions than making it illegal to build and deploy the software that is substantially used by non-criminals. Which, just to throw this out there, I think it's it's not by any means a hand wave to get out of the fact that there are real problems with this technology existing. But the prosecution really went out of its way to pick periods of time where these big hacks had happened, and you could say that like 50% of the money going through Tornado Cash was criminal proceeds. But often that was like, in one case, it was one day where 50% was criminal proceeds. In another case, it was a couple of months. But over the course of the 2-year period that the trial was paying attention to, only 20% of the under 20% of the money that was identified flowing through Tornado Cash was known criminal proceeds. And, the defense kind of demonstrated that once you get past these few big ones that we know about, the volume coming from crimes is probably pretty minimal. So it probably is something like 20%, which really speaks to the fact that there is this huge demand for, for just private citizens who want to anonymize their funds and have totally legitimate reasons for wanting to do that. And so, this is not a win per se, but it is certainly not the worst case scenario. And it's going to be a continuing process to get that message across both through the courts and to the public.
Well, David, we thank you for all your important work and your attention to detail in this case. Where can people follow you and get more into the coverage details here as it continues to unfold?
Yeah, so follow at The Rage Tech on X/Twitter. Hopefully we're expanding to other platforms soon. You can follow me personally at David Z. Morris. And also subscribe at The Rage. I have a personal sort of financial fraud newsletter called Dark Markets at davidzmorris.substack.com that you can check out. And yeah, we will hopefully be, continuing to put stuff out. We have a YouTube channel now, so all these little things are coming online. Watch and we will also be asking for support from the public. So keep an eye out for that.
Also, if you have the time since you're here, check out the archives on Supply Shock on YouTube or wherever you're getting your podcasts. Other episodes that we have that dig into this subject, most recently, Gabe Shapiro, a brother of Julian Assange, coming to talk about the importance of the work of WikiLeaks and helping bootstrap Bitcoin, and even today inscribing some of that important work for all time on the Bitcoin blockchain. You can go check that out. Give this episode a like or a comment if you've followed the whole way. Otherwise, we'll see you at Digital Asset Summit in London later this year. We hope you'll be following the podcast all the way through then. For now, this has been our show. This has been Supply Shock, a Blockworks podcast.